Good morning, everybody. I would like to welcome you to the webinar today. Alongside myself and my colleagues Rob and Charles, we hope you enjoyed the next hour. So just without any more taboo, I will get things rolling. So just a little bit to start off with, we have an agenda for today. So we have we'll just run through a few housekeeping bits, there'll be introductions, and then we'll go into the full presentation as was summarised in the invites. So firstly, just let everybody know all attendees will be muted. If you have any questions at all, then please put those through onto the question box, which myself, Kate Rounding, will be monitoring throughout. And we will then address all of these at the end of the webinar. So I'd like to just start by introducing Charles Christian, who is the Editor-in-Chief for the Legal IT Insider and legaltechnology.com website. He has got quite an amazing background, and if you go through and look at the details on the site, you will understand just the experience he has and why he's a great person to have along on this webinar today. Also, my colleague Rob Kenny, he has been working with ZyLAB for 14 years, both on a technical and commercially focused roles within the organisation. Really broad experience of eDiscovery and everything it has to offer. So the contact details for both of these gentlemen are on these slides, and they will be made available to you post-event. So I'll pass it over now to Rob, and enjoy the next hour.
Good afternoon. So what we're going to do is we're going to start with just a little bit of information about what eDiscovery is. eDiscovery, I'm going to sort of do a sort of simple schoolboy cheat here. I'm not going to go from Webster's, but I'm going to take a definition from Gartner. eDiscovery is the identification, preservation, collection, preparation, review, and production of electronically stored information associated with legal and government proceedings. Now, just to confuse things as well, eDiscovery is sort of a US term. You may also hear it referred to as eDisclosure in the UK. They're sort of interchangeable. But yeah, we have a nice collection of words there, a few good hands at Scrabble. But at its heart, it means the most important thing is that we are finding relevant documents from an ever-expanding set of corporate archives, or discovering what electronic documents you actually have.
I think as well at this point, Rob, I'd like to raise a couple of other issues. Is Charles Christian speaking.
Yep.
One of the things we hope to do this afternoon, if you like, is debunk some of the myths surrounding eDiscovery, particularly that it's something only Americans do, that it's only relevant in mega-sized cases, that really you can leave it to the last minute, because we all know 90% of cases, 99% of cases settle before court, and actually you don't need to worry about doing it in-house, because there are plenty of litigation support bureau who'll do it for you. And as I think these are certain myths we will be looking at and hopefully debunking during the course of this afternoon.
Yeah, yeah, that's I think is one of the main things for this webinar. Is a lot of people hear the sort of the term eDiscovery and they either switch off or they just, well, that sounds a bit strange, and it's not really something we need to bother with. Yeah, so you'll sometimes hear the sort of an abbreviation EDRM, and that's the eDiscovery reference model, and that's not to be confused. We're an IT, we're IT based. We love our acronyms, so it's not to be confused with EDRMS, which is when talking about electronic documents and record management systems. Now, whenever you're going to start looking at eDiscovery, you're going to see this graphic, which is why we have, this is the obligatory EDRM graphic. Now this chart shows the various stages that typically you'll work through in an eDiscovery process. Now it starts right at the far left-hand side with information management. Now information management, that doesn't sound very legalese, and it's not. And I think at the heart of any corporation or any company, big or small, good information management should be there as part of a normal way of working. And as it goes through, we can also see at the bottom there's the sort of two triangles. One as volume sort of starts to go down. So as the idea is, as people work through this this model, the amount of data they're dealing with will go down, and the other triangle, relevance, will go up. So as they're going through, we're getting rid of documents that don't mean anything to us and just keeping the ones that are relevant to what we are looking at the moment. So with following on from good information management, the next stage is identification, which in this case means, well, who has the documents? What are the document types that we're looking at? And if we are looking at identification, problems at this stage can be costly, because if you misidentify, if you don't have the right people, then there's going to be issues along the line. Now, once we've identified the documents, we then have to collect them. So we want to place them, we want to preserve them as well in a place to stop them being modified or deleted. It's we don't want important documents to go missing in a legal process. In fact, we don't want important documents to go missing full stop. And this could be awkward as well, because if documents do go missing, then some jurisdictions will fine you, and it can be quite large amounts, whereas other jurisdictions, they won't look so kindly on you in the course of the final judgment. And then once documents have been collected, you then enter into this sort of dance of processing data, reviewing data, analyzing data. And so the idea is, with processing, is you may have file types that aren't particularly easy to look at. So it may be, for example, zip files. So you need to open the zip files to see what's in them. It could be PST files. You could need to deduplicate them. There's a lot. One of the wonderful things about technology these days is it's given the ability to duplicate and duplicate and duplicate information across a wide variety of sources without actually realizing that we're doing it. And so probably, you could look at maybe 10–20% of a corporate network at least is consisting of duplicate data that resides in more than one place and isn't really being looked after by anybody. So we're a lot of doing that, we're deduplicating that. We're trying to also maybe look for documents that are similar. We're then reviewing the documents and analyzing them. So analysis can help us spot patterns in data. It can also help us maybe adjust the processing, because we're seeing things that don't make sense at the moment, or we're identifying during analysis file types that need additional processing. And so the review phase itself, typically, we're looking to see whether or not documents are relevant to the case that we're looking at. And this is an iterative. I'm sorry, I think I was muted. Okay. Okay. Sorry, a problem there with my audio. Let's go back a stage. So what we have here is the eDiscovery reference model. Now this is pretty much, as soon as you start talking to anybody about eDiscovery, then you will see this graphic, and it will become burnt into your mind over the course of time. And again and again and again, whenever you talk to a vendor, one of the first things they'll do is they'll show you this graphic. And they say, well, we do everything here. And if we look at the chart, the whole idea here is that we start from the left-hand side with a large volume of data. And as we work through this chart, we end up the volume of data decreasing, but the relevance of what's left is increasing. So it starts with information management, which is really the heart of good business management. Storing the right amount of information for the right amount of time in the right place. And with information management there working, then it makes the rest of the stages a lot easier. So following on from information management, we have identification. So who has the documents? What type of documents are they? The information we have there from the information management can feed into that. And then we go into the stages where we start collecting the data and preserving it, because we want to make sure that in a legal case, we don't want that data to suddenly go missing because somebody's gone and deleted it, because that can cause us a lot of problems. Legally, depending on this jurisdiction, you could end up with some fines. You could end up with adverse judgments. Then we go into a whole processing loop. So we look at processing the data, reviewing the data, analyzing the data. Now by processing, we mean making the data easier to review for whatever reason. It could be we're looking at zip files, which have obviously files inside files. PSTs, which have emails in, and the emails have attachments. So all of that needs to be put into a format that can be easier to review. Also, we could be then starting to look at deduplicating files, removing things that we don't need. So during this processing as well, we then start to analyze what's been processed. And then from there, we carry on with the review, and this can loop round many, many times. Now, once the review has taken place, as you can see on the graphic, during this phase, this is where the data, the relevance is starting to go up. So then we have the information that we need, that we believe is relevant to our case, where we then do production. Now, production takes documents that have been identified as relevant during the review phase and puts it into a format that can be exchanged with another party, so the other litigants, for example. Typically, these formats are either like native files, so the original application that generated them, so Word documents, PDFs, Excel spreadsheets, or image files, so typically either TIFFs or PDFs. And these are normally exchanged along with some metadata about the documents, so where they originally came from, who originally had them. Now, each way of processing and production has its own sort of pros and cons. For example, disclosing natively will mean that you possibly are giving away hidden data. So maybe, say, proprietary formulas in spreadsheets. Whereas in TIFF images, it's just an image. There's no additional information behind there. And finally, presentation in court So it could be that you're having to put this information onto computers to take into the courtrooms. Now, this isn't it's starting to happen in the UK, where the courts are starting to have these ways of providing evidence in court electronically, rather than having great big bundles of paper. And if we move on from sort of that, there's as Charles said at the beginning, there's I think a belief that eDiscovery is something that happens to other people. It's not something that will happen to them. I mean, we run a very tight ship here. There's no problems like that. It's oh, it happens to other people. Far too expensive. We needn't worry about that. A good service bureau will do that. Nothing to worry about. It's not really a good plan. It's a risk. It's a big risk. Not thinking that it's something that's going to happen to you. It's a very sort of Chicken Little type attitude to have. And even if you sort of believe in, well, we'll get a service bureau, throw it over to them, they have to worry about it. They'll worry about all the, they'll have the risk of processing it properly. It's not the case. There's recent court cases. So in the U.S. Burge Helene versus General Electric Oil and Gas, there was an issue where they handed the data over to a third party. The third party didn't process it correctly, and the sanctions were then in court, not on the third party, but on the actual company themselves. And so, there's...
I think if I can just come in there, Rob, one of the other points is that whereas we used to think large-scale litigation support cases were something that only happened to everybody, there is a growing real that organizations have so much electronic data now that it could happen to them. There is just so much material there that you cannot physically sift through anymore. I don't know if you've got any of those handy stats people have about if you take the average Outlook mailbox and printed out all the paper and then try to analyze it by hand, those sort of figures. There is just so much information floating around corporates and indeed law firms that electronic discovery is something that is going to be unavoidable in litigation.
Yeah, I think, I mean, not so much those figures, but it's interesting that the amount of data that people are producing these days is scary. I mean, it's something like 90% of all of the data that we create as businesses is unstructured, and of that 90%, 80% of it is of no use after maybe 3 months, but we still keep it, and it's very, very scary because like you said, nobody can actually these days really get a real grip on what they have in their corporate archive, and that feeds back into being able to have a good information governance process. It is sort of core there.
Yeah. And of course the point with litigation is, although 80% of that data may never be needed and used again, you need to make sure that the key information, the smoking guns or whatever, are not lurking in that 80% and have been ignored and missed.
Yeah, this is the issue. You have to be aware. Now, either you have to you undergo regular, what we call legacy, or what Gartner calls legacy data cleanup. You regularly look at all the stuff that's just lying around in your network, and actually look through for things that shouldn't be there, for the smoking guns. And I mean, that's another way where the actual tools of eDiscovery can actually be used not to run a case, as it were, but to actually investigate all of the nooks and crannies within your corporate network, to try and make sure that there isn't a smoking gun there at some point. So you're almost like running your own internal fire drills on your data. And I mean, you know, eDiscovery is not just for litigation. I mean, the Gartner definition talks about government proceedings as well as legal. But I mean, you know, legal is not just court cases. It's not just litigation. There's you know, regulations that you have to follow. So government regulations maybe, or compliance regulations within the law. And so you have your Freedom of Information Act, for example, where, you know, you have to look through your data. You know, somebody says, okay, give me all the information you have on me, or, you know, tell me about, for one case, about army patrols in Northern Ireland in 1970s. So, you know, you have to go through your archive, and you have to consider also the fact that your archive may contain personally identifiable information. So it may be that you're storing, you know, credit card details, for example, people's dates of birth, national insurance numbers, and that, you know, you are going to have to, you have your 40 days to disclose, but you're going to need to redact that information before you disclose it. And don't forget also, there are going to be fines around that for non-compliance, for non-disclosure, or for failing to hit that 40-day mark. So having, you know, the following, say, the eDiscovery process, which is designed to go through data, take you through a process to cut down, to find what's relevant and produce it, and to use the tools and software that have been built around those processes. You know, there's a huge cost saving there for people. And the same with compliance and regulation. Again, you need, you know, to look through your mighty corporate archive. And it may be that following a specific request from a regulator, or it may be just that, you know, you have a suspicion. You need to start looking through. So, you know, bribery, for example, is one with the UK Bribery Act. Banking regulators double checking, you know, that you're not trying to fix LIBOR rates or whatever. You know, again, the eDiscovery software is there, or can be there in the eDiscovery process, to help you through the whole working through all of that data. I mean, it just makes so much sense that people, intelligent people, have worked on this process. Intelligent people have developed software to do these sort of tasks. It doesn't make sense to try and do these things manually, or to try and, you know, recreate the wheel here. Yeah, and especially now, there's you know, the changes that have gone in place recently. I think with the Jackson reforms, which I think you're going to, you know, you can probably tell us a little bit more about.
Later, yeah.
Yeah.
Yeah. I was going to say just one other point on while you were going through those issues. I've heard of one large UK corporate that is now using its eDiscovery software for even such routine things as running a quick query through its database when it's asked by a long-serving employee to write a review, because there's obligations to the other side if you give an unfair review or an unreliable review to an employee. But if you've had somebody who's worked for you for 20 years, there's all manner of correspondence relating to them, and it's unlikely that the HR department are familiar with every element. So even for routine things of that nature, it's now, well, you know, how do we know that there wasn't some issue in the past, that what we're saying is justified? So run it through with eDiscovery.
Yeah.
I think it's one of those tools that once organizations get it and start using it in-house, they realize, well, we don't just need it for litigation, we don't just need it even for corporate compliance and administration. There's an awful lot of non-contentious, routine work goes on where it's just a great tool to have around.
Yeah, well, especially, you know, corporations these days, the wonderful thing about technology is it's given us lots of different systems to store stuff in lots of different formats, and having some sort of consistent way to search across that, to investigate that, to help with these, you know, mundane or day-to-day matters is very useful.
Right. Can we move on to the with the Jackson slide?
Yeah, because I think the Jackson reform are quite interesting. So yeah, you know, can you tell us a little bit more? I know I've sort of.
Well, I'll tell you a little bit. I mean, we're in a position that all of us are starting out with Jackson, as it only was implemented on the 1st of April this year, and the effective case law on it and experience of using it, it's still very much early days. So we're talking about general principles of how we think it's going to happen, as distinct from hard and fast rules. But I think the basic element, obviously Jackson covers a lot more other than just e-disclosure, but I think the basic element that is relevant is that it brings in the concept of the case management conference, which will take place at an early stage. So once more, going back to one of the points I made at the beginning, the old idea, well, you don't need to worry about discovery things until the very end because they'll settle anyway. Now it's no longer that case issue. Now it will arise at an early stage, and you are going to have to go into your case management conference fully up to date on your data. And one of the issues you're going to be discussing there is what is the approach going to be on disclosure, justifying the elements of disclosure that will be taking place, looking at things such as proportionality, in particularly how much the cost of the research is going to be, how much the cost of discovery is going to be, and peculiarly, or you know, as a change from the past, it doesn't even matter if you could argue that these are reasonable expenses and necessarily incurred. If they are completely disproportionate to the value of the case, then they're going to be disallowed. It's no longer a case of, you know, no longer a situation where if you're talking about a £10,000 dispute and you can say, but it cost us £100,000 to do it, therefore we've got £100,000 of costs. That's not going to be the situation anymore. You're going to have to be able to justify it. And another element of these case management conferences is that you will be discussing budgets, almost setting budgets for how much research is going to be going on there. So the point, the general point is, it's no good worrying about these issues, how much discovery we're going to do, eDiscovery going to do later on. You are going to know at the very outset, you're going to need to know at the very outset what the likely cost to be. So you're going to have to have done some of the preliminary e-disclosure work before you even set foot in the case management conference room. Otherwise, you're going to risk budgets being, you'll be given a low budget, rulings against you. So I think the key element is Jackson means you've got to have a handle on your electronic data from the very outset of the case, no longer leaving it until the very end and just hoping that it will settle.
Yeah,
Does
so
that really sort of fit in with your view, Rob?
Yeah, and I think also the fact, I think it's useful if you've undergone litigation in the past, if you can have those figures to start to build up some knowledge about, okay, well, who are the key custodians generally in a litigation within our company? What sort of data do they hold? So maybe last time we looked at 10 different people within the company, and each one of them had on average 12 gigabytes of data which then cost us X amount to process, which cost us X amount to review. So we could say that overall it cost us, say, £25 per document to review. So that when you come along to these, to the case management conference and the budgeting discussions, you can then, you have those figures to hand. So you sort of got an idea as to whether or not the budgets that are being discussed are actually reasonable and valid in your case. But also you can then, you have an idea when the other party says, well, we're going to spend X amount. You can say, well, hang on a moment, it shouldn't cost you anywhere near that amount of money to do the processing or to do the review. So it gives you, I think, the knowing what you've got. So going back a bit to information governance, knowing your sort of litigation history as well, and knowing what information, the risks on a day-to-day basis, you're going to be a lot more switched on when it comes to the case meeting.
Yep, I totally agree. I think the mentioning there about gigabytes and so on brings us nicely on to the next slide about innovative pricing.
It does, and I do apologise to any T.S. Eliot fans here. This is obviously a slight misquote from the home, but this is the way gigabyte pricing ends, not with a bang, but with a whimper. And we are starting to hear sort of a death rattle for per gigabyte pricing. I think in London at the moment, or you're looking at round about £100,000 to process a terabyte of data, and that's just not a pricing model that can be sustained. I think probably maybe within the next 6 years we're going to reach the point where we're going to look back at per gigabyte pricing the same sort of way that we look back now at the Victorian era and sticking children up chimneys. And I think I think there it's an anachronism. It's sort of come from the days when we didn't actually have much data, and even then we were charging huge amounts of money to process quite a small bit of data because it was very specialist. Now the data is expanding, but also the knowledge of how to do this is expanding. It's not now just the purview of specialists. There are tools out there, there is training out there, so that it can become useful for and be used by a lot more people. So it is become an anachronism there, and I think some people they talk.
I was going to say, what sort of alternative pricing do you see coming along? Because I mean, to an extent, charging by the gigabyte is almost like lawyers charging by the hour.
It is. It is, and I think probably. I mean, there's obviously you could say, okay, well, you get a discount on because we've got a one-eyed reviewer, but I mean really, I think the one that seems to be coming out at the moment more is a per document cost. So you're looking at a fixed price price unit, and the only way really, if you if you are doing all of the work, you've got your information governance, as we keep saying, you've also got your litigation history, so you know how much in the past it's been costing you per document to review. You can start to negotiate at least maybe the first, what's called the first pass review, where the whole idea is to reduce down the amount of documents to a much more manageable set to hand over to more experienced lawyers. So I mean, I think Lehman Brothers a few years ago, they got the data together and were able to start negotiating, rather than per gigabyte pricing, per document review, so fixed unit costs, and they saw like a 60% reduction in review costs at first pass review. So being, I think that's still at the moment seems to be the way the business seems to be moving, rather than any other sort of way.
Yeah. Sort of moving on from there, what about one of the other myths we were talking about, the fact that, well, there's always a bureau out there to deal with it, because we're definitely seeing a growing trend for eDiscovery being brought in-house.
Yeah. I think the issue, obviously, normally with eDiscovery, like you said, lawyers are compensated by the hour, whereas we want to manage expenses. So there's a big difficulty there. And also, there are dangers always if you start moving your data outside the company. And obviously, it's a risk. So, you know, you do your risk management, you make your choices. But what you don't want to be is somebody in the legal department that receives a phone call one day saying, okay, pay us £80,000 or we get rid of all of your data. You know, sort of a blackmail attempt, which is actually what happened to GlaxoSmithKline recently. They had been working with an outside vendor since about 2004, and this outside vendor, over the course of years, they had maybe almost 50 terabytes of litigation documents there. So if you want to try and visualize that, that's about 3.75 billion pages spread out in unknown locations, so in various servers across various data centers. And this was like core, key to the kingdom, corporate data that was being used for litigation. And you know, it had already been processed, etc. And you know, it was threatened to be gone unless it was paid. And the other, because the company was undergoing financial issues, and so there was also then the issue that if the company went bust, what would happen to the company assets, which are all the servers, which contain all the GSK data, and we're talking, like I said, proprietary data, trade secrets, competitive information, privileged communication, and what would actually happen with that data. And so, you know, it could be then that it's sold off on eBay and somebody's buying the discs and finds, you know, a whole bunch of information that could, like, literally put GSK out of business. You know, and okay, that's a scare story, but it's a real story. It's not a, you know, something that's just been made up to frighten small children and corporate lawyers. And I think the benefits there of bringing eDiscovery in-house, certainly maybe even using it maybe just for the first few stages, is the control of costs, because you are then, you know, you're not looking at sending stuff out for per gigabyte processing. You're not also then having to worry about handing over huge amounts of data to an external lawyer to start reviewing on a per hour basis. You know, you're going to have better access and audit capabilities, so that if you are letting external law firms go in and look at your data to review it so that you're getting more information, that you can actually see and compare the bills. I mean, I've heard two stories where you know, bills have come in from external law firms, and for one, it was they were charged 3 hours for a senior reviewer. They went and looked in the audit trails, and they saw, yes, the senior lawyer logged in at 9 o'clock in the morning, and he logged out at 12, and he didn't do anything. He didn't do any searches. He didn't look at any documents. He didn't do anything at all. It just, you know, gone into the main screen. But they'd been charged for that time. And being able then to have those audit trails gave them the ability then to sort of renegotiate the pricing. And also I heard another one where a similar sort of thing, the bill came in and they thought it was a bit excessive. And so they started to look, and there was not even, like, you know, people going in and doing a review. This was, they were being billed for meetings with people from the corporate side. The lawyer was billing for a meeting with Bill between these dates, and Bill was on holiday for 3 weeks. So, you know, and, you know, comparing up diaries, they were easily able to find at least 10% of the bill was they just couldn't justify, because the people that were supposedly in these meetings or doing this work in conjunction with the lawyers that they were being billed for just weren't around. They were either on different projects or they were, you know, on holiday. And so, you know, you are being able to, like, as we're moving on to, you know, controlling the legal spend. And I think that is probably going to be the biggest benefit. And you've got to be careful there, I think, with trying to balance up. Sometimes you see the cost maybe of bringing the software in-house, and you look at it maybe on what's an on-demand basis. So you say, okay, well, we'll use it for this amount of data or this amount of documents. You know, so you're still sort of paying a per gigabyte charge, but you know, you're not owning the software, but it's installed in your data center or in your server room, and you sort of control and administer it. But you know, maybe if you had more information at the beginning about the costs and the typical sort of size of the case and the amount of litigation you normally undergo, then maybe it would have been cheaper to actually purchase the software outright. And to do that processing.
I think another point.
Mm-hmm.
Sorry, I was just going to jump in there on another point. What you were making there is with controlling legal spend, that perhaps it was once acceptable that you paid law firms and, for example, the big eDiscovery consultancies large amounts of money when you were dealing with life or death litigation, major commercial disputes where, you know, IP rights are in dispute, the company's future could be imperiled. But the entire situation changes when it's down to routine, freedom of information inquiries, things of that nature, where you know, where there's a nominal amount of money you can actually charge somebody for your inquiry. You don't want to be running up a £10,000 bill with a law firm for them to search through it. So, you know, I think the element where you know, going back to the earlier slide about litigation is for life. It's not just for Christmas and for, sorry, eDiscovery is for life. It's not just for Christmas and litigation. That has changed the dynamic, and corporates are having to think, actually, it doesn't need many routine inquiries, and we will have paid for the software, and we will have it will be a more cost-effective solution than outsourcing.
Yeah, yeah, and again, it's sort of going. It always seems to go back for me to the sort of the information management, the information governance, and the litigation history, and the information that you can gather from that. Because then, like I said, if you've got those figures, you can start. If somebody comes in and says, "Well, it'll cost you X, Y, Z to do this," you know, you already have the figures there, and you know, well, no, it's not. It's not going to cost that. It's going to cost, you know, it's going to cost a tenth of that or half of that. You then become in a position of power because you have all the information to hand. You know your figures, you know, and it's not just in terms of you know, your normal data, so your personal share, your shared folders, but it's also things that are stored on, say, your corporate wiki or your SharePoint that don't really have proper owners, that you still, you know, you're still going to be needing to look at and be able to search and to find and process in, like you said, any number of ways, which some of which are very, very boring, you know, typical day-to-day work, and others can be, you know, quite exciting. But I mean, these figures as well, it's not a one-off. It's not a one-off thing. It's something where, you know, it's a regular review. It should be maybe every quarter or every 6 months, depending on your litigation profile. You should be looking at this again. You should be understanding a bit more, because, you know, the corporation. Most corporations are not sort of static beast. They're changing. Plus, technology is bringing in new risks and new rewards within the system as well. The ability to store it used to be, say, the ability to store your faxes electronically as they're coming straight in. These days, it's being able to have your voicemail, emailed to you rather than having to dial into a remote, remote place and listen to them. You can just click on them and play them within your phone or within a web browser or your email client. And these sort of things, so they're changing again the sort of the requirements of anything you do as a business. And if you can't keep a good housekeeping on those sort of things, then you are going to come a cropper, and you are going to get what gets termed as bill shock. Where you have no real idea until the end. No job is too small, no fee is too big. And also, whenever you're dealing with a third party, you need to make sure that there's a communication between the parties. So you're not doing work you don't need to do, on one hand. On the other hand, you are making sure you're doing enough work, because you don't want to go back to produce everything, do all of the work that's necessary, then to find out with the judge then saying, well, no, because you should have done this as well, or we don't think that you looked at the right people, as happened with Digicel versus Cable and Wireless, where they didn't talk to each other. They both did their own sort of work, and they chose their own custodians and their keywords to look at, and the judge took one look and said, this hasn't been done properly. You have to go back and do it all over again at your own expense. And you have to think then as well, okay, well, let's look at it and try and find a pricing model that suits you. If it's not per gigabyte or price per unit, then what is it? Do you try and look for something that gives you, say, a pricing just on the number of people that are going to be doing review, and that's it, or other sort of solutions, and work with the vendors and say, well, I don't want to pay per gigabyte, I don't want to pay per document, I want to bring this in-house, so I want a simple single price that I can understand for the software that will cover the sort of our typical litigation, each year, with maybe some room for growth, one way or another. So what is it? And it keeps coming back to that information management and being able to have those facts and figures together, so that you can marshal the data that you have, marshal the information you need, and then you can be a general in the case management conference rather than just a foot soldier.
Yeah, it all comes down to project management, which is what you touched on, and the whole emphasis of Jackson is that there is an element of what in the outside world would be called project management involved in running the case, and as you've rightly pointed out, in the in-house purely administrative, regulative use of eDiscovery, again there's an element of project management to have an idea of what volumes of data are being used, how they are being processed, can you find cheaper ways of doing it. Say otherwise, it's not just a case of you get the project creep, but the budget starts creeping up and you get the slippages, and then particularly if you are general counsel, you suddenly discover that your legal bills are going to be far higher than you budgeted for because they just slipped here, there and everywhere. So I think there's a whole element of more professional project management of the information that the corporation has at its disposal.
Yeah, I mean, gone are the days when there was like unlimited legal budgets and things like that. And also, I think, it's not only what data you've got, but it's also what data don't you need anymore as well. So you're making sure that you're not keeping stuff you shouldn't be. And again, that has a knock-on effect because you're reducing your storage costs, your backups, and IT will be happier because then if there is money available, they can spend it on other toys rather than the daily grind.
Yeah.
Yeah, I think in the end.
Yeah. Sorry, continue.
Well, no, I think with more and more companies realizing that they need to take control of this, I think, and then bill shock is going to be sort of disappear away and become go the way of casual Fridays.
Yeah. Yes. I think another point on there again comes back with one of the myths we had about it only matters for big cases and you can leave it till the end. The way it is going with Jackson and generally being far more proactive about getting a handle on the corporate data is that actually you may be able to resolve, even if it's settled, it may be even settled at your disadvantage, but you may be able to resolve cases quicker, which is ultimately cheaper for the organization if you have a better handle of the information, and if you discover there really is a smoking gun and oh, we really did put out an email that said that at an early stage rather than go through the long processes. And so again, it's an element of eDiscovery tools allow the corporation to be more proactive, find out if this is, when it's on the receiving end of a lawsuit, whether or not this is a valid claim or whether or not it's a one that can be legitimately disputed. So I say that there is a couple of ways of looking at it. Yes, there's the cost of investing in the technology, but there are the savings in time, savings in potential use of outside legal counsel, consultancies, etc., that will be reaped and enjoyed by having this better handle on the data at an earlier stage.
Mm. Yeah. So I mean, I think we've sort of summarised as we've gone along almost every single slide. We've summarised on information governance, information management, understanding your litigation history, and also the fact that it can be across everything within your corporation. It's not just for legal matters. And going, as I said, we keep going back through these points. The fact that with those sort of things in place, you're going to be able also to be a lot safer if it does come to. Well, I say a lot safer. It will always depend on whether or not you were doing wrong or not, but a lot simpler and a lot safer when it comes to litigation.
Yeah.
Right, and on that note, I'd like to say thank you to both Rob and Charles for their time here. There are a few questions. If anybody else has any questions that you haven't submitted yet, then please fire them through. But I will pose the first one through to Rob and Charles now, and that is, what other departments in large organisations might you suggest for eDiscovery tools in addition to HR?
It depends on the corporation, but certainly if you are like project departments, so you're dealing, say, construction, so you've got projects for buildings, that sort of thing. If you're creating things, line of business as well, you're dealing with finance, so contracts, terms and conditions, that sort of thing. So it can be used. I mean, we always use HR, I think, as an example, because a lot of things tend to happen in HR. We have a customer in the US that has 2 people in HR whose sole job it is to deal with requests from divorce lawyers for email between 2 people. It's a it's a large county. So HR is always like, people see it as the easy bit because there is so much potential there. But yeah, certainly, for example, the finance department is another one where, as I said, we're dealing with contracts, negotiations. That's also potentially where there may be issues around compliance with the Bribery Act or with financial regulations and things like gap reporting and are you reporting correctly?
Yeah, I think what would also be still the relevant department, but what used to be the company secretariat department, just for keeping a handle on everything, and particularly when you are dealing with global corporations with all the various different compliance regimes they have to look after, just keeping track of everything. I can say it really is, as Rob's mentioned a couple of times, it's an element of it's in a way a project management tool, just for keeping track of things.
Okay, another question here, and that is, what % of law firms do you work with do you believe understand the requirements of the Jackson reforms in terms of case budgetary?
Oh, that's a good one. I don't know.
So case budgetary control even helps if I read the last word.
I'm not sure. I think, as we said, the Jackson reforms have only been in just over a month now, and I think, as Charles said, there's not really enough case law that's been built up yet around the new reforms for anybody to be an expert, probably apart from, obviously, Lord Jackson. So, yeah, it's still still early days there, I think.
Yeah, I agree with you there. The point is, obviously, Jackson does have consequences for other areas of litigation besides the larger cases where eDiscovery and the case management conferences are relevant. And I think at the moment the key thing I've seen is that there are probably more people holding forth at seminars on what Jackson means than there are actual people dealing with Jackson on a day-to-day basis at the moment. But I think that will settle down in the next 6 months or so. We'll probably have some supplementary practice directions to clarify certain issues, because any new regime never really survives the first encounter with a contentious dispute, and I'm sure that in 6 months' time we will have an entirely different perspective on Jackson. At the moment it's far too early days. Everybody's talking about it, but nobody's really doing it yet.
Okay, I'm just double checking now. I think the only other question I can see here, unless anybody else has got anything, is that will these slides and audio be available? Yes, they will be. I will be making sure that there's something sent out probably beginning of the end of this week, beginning of next week, with a link to a copy of the recording. If you also want a copy of the slides, then they can be made available by myself, Kate Rounding. You should have my contact details through the invites and the registrations that were sent. And if you have any other questions at all for myself or Rob or Charles, then please fire them through to me and I'll make sure that they are answered. So I'd like to thank you all for coming along and listening into this presentation. If there are any more questions, fire them across, and I hope you'll have a great day. Thank you very much.
Thank you, Charles.
Thank you very much.
Thanks, Charles. Thanks, Rob.
Bye.
Thanks.